Catherine Delahunty.
Mr Speaker, with some reluctance, the Green Party will be opposing this bill. Reluctance because there are a number of innocuous provisions, and in principle, we support the secondary tertiary partnership that this bill enables. Secondary school is a challenging time for many young people, and school in its conventional form is not for everyone. Too many young people will become disillusioned with the school system and leave without qualifications because their interests and learning styles are not taken account of. I have been engaging with secondary school students in a research project about learning models, and many from alternative schools, many Māori and Pacific in particular, have identified the need for far more diverse and exciting learning models, but not necessarily workplace training for all. So recognising this, there is still a need to provide for learners who need to undertake workplace training and apprenticeships, as secondary tertiary partnerships do, and that is positive. We see that as positive. We supported the clauses in the previous Education Amendment Bill which allowed this initiative to be developed in Manukau. However, we do have some concerns about how the partnerships may be developed. But this is not our major concern with the bill, and we cannot support it as a whole. The problem is that these omnibus bills are difficult because the government tries to sneak in unpalatable changes behind positive ones, and there are elements of the secondary tertiary partnerships as well which we do find problematic. So to take the parts of the bill we're concerned about one at a time. As well as setting up secondary tertiary partnerships, this bill would exempt so-called limited attendance early childhood centres from having to comply with early childhood regulations. The excuse for this is that the kids are only there for a short time and the parents are always close by. But we are concerned that this is the thin edge of a wedge. Already we are seeing the same government watering down the requirements for staff to be registered teachers at all early childhood education centres. Our contacts in the sector warn us that this further change could put children and babies at risk and could signal further erosion of the safety and quality of the sector. Whether it is 2 hours or 10 hours, there are standards of care that must be met. It may be cheaper for the provider to lower standards and easier for the parents to just drop the kids off somewhere while at the gym or while shopping, but the Green Party is more concerned about the standards which all children need at all times. We are unimpressed with the undermining of the ECE sector in terms of reducing the need for fully qualified staff, and we don't support any further weakening of the commitment to high-quality childcare in any creche or facility just because it would suit adults. But it won't help the education system, which is what this bill is allegedly set up to do. However, the real mind bomb in this bill is the proposed enrolment provision changes. Anyone would think that the government was trying to import private school values into the public sector. There is a particularly odious so-called minor amendment to change the enrolment priorities for out-of-zone enrolment for schools so that children of former students and board members are prioritised. We find this distasteful and think it formalises an old boys club in a way that is neither necessary or acceptable. In a change blatantly aimed at improving the profits for private training establishments, the bill makes it harder for international students to withdraw from their courses within 10 days of starting them by allowing the Minister to limit the refund establishments which have to be paid by students who withdraw. The regulatory impact statement about this bill focuses entirely on the security and financial position of the private training establishments. Not once does it consider the experiences of students who might arrive in Aotearoa, New Zealand, and find the course they enrolled for is not what they expected. It is short-sighted, and it does nothing to improve the experience for these students or the long-term reputation of our international education centres overseas. Other parts of the bill are less objectionable, like those giving effect to the Law Commission's recommendations about the law regarding private schools. However, many useful recommendations have been watered down in this bill, once again with the interests of private schools rather than students paramount. For example, the government has chosen not to implement the recommendation that private schools be required to comply with standard procedures for disciplining students, suspending or expelling them, because it would be onerous for private schools to have to amend or write consistent guidelines around this. This is simply not fair for students who may find themselves in the position of being suspended or expelled from private schools without clear guidelines and recourse to that decision. Similarly, the Law Commission's changes have been watered down with respect to sanctions against private schools which fail to comply with the law for registration, again with the interest and convenience of the schools paramount in the government's mind. So finally, although we are broadly supportive of the changes around secondary tertiary partnerships, we are concerned that as drafted in this bill, these changes could pave the way for future unacceptable privatisation of parts of our public education system. We opposed the last Education Amendment Bill because it allowed body corporates to become statutory managers of schools in some circumstances. We saw this as unacceptable because it prepared the ground for public-private partnerships, which could see corporations running schools in the same way that has already happened with disastrous consequences in some places overseas. Now those same body corporates will be able to form secondary tertiary partnerships with other private institutions in the tertiary sector. And we are concerned at what this might open up in the future, given that they can be the lead provider. And we particularly are objecting to the bill because of the provisions around enrolment. And I support the comments that Calvin Davis made about elitism and about the access of local children to local schools. We particularly support the rights of local children to attend local schools rather than protecting a dynasty-based access for the privileged few. Because a lot of parents and children don't have the choices to move to where the schools are. A lot of them need the high-quality public education sector that Kelvin was referring to. And it's not about providing real choice if you undermine the zoning issue and also the issue of local parents having access to those local schools. As somebody whose father went to Auckland Grammar School in Auckland, I don't see why I should have access simply because my father went there. He lived in the zone. I have never lived in that zone while I was a high school student. Why should I be privileged over the students who live in that zone? I was on a board of trustees at a particular rural school. Now, why should that mean that my descendants get privilege? This is all about setting up dynasties rather than relating to local needs. The public education system is meant to be public. It's meant to be open to all students who live in that area, and it is meant to be of the highest possible quality. And because of these range of issues which we're concerned about in this very broad bill, and with great reluctance because we do see the value in some of the provisions, the Green Party will actually be opposing this bill. And it's unfortunate that we're in this position, but yet again we have to point these things out because it seems sometimes as if nobody else will. And we are hopeful that perhaps some of our concerns will be amended at Select Committee, and we'll certainly be raising the issues in the Select Committee. But we are basically concerned that this bill is not about education. It's about things like parents going to the mall. And that's not what the Education and Science Select Committee is there to debate. Should parents go to the mall and have a nice, easy way to drop off their kids? That's not what we're there to do. We're there to improve the achievement levels, the diversity, the viability and the accessibility of the public education system for all students. We already have gaps in the society between the rich and poor, and the Green Party has spoken many times about the gap. And we don't want a public education system at this time in history to reinforce that gap in any way or in any shape or form. So we will be watching the bill closely. We will be looking for good things that we can constructively assist with, but we will be, at this point, opposing because of the issues I've outlined. And I'm not speaking alone. I'm speaking with the backing of the early childhood sector on these issues. I'm speaking with the backing of many people who work for the concept of local schools being available to local children. And also, we are watching this space on the issue of secondary and tertiary partnership. It can be a really good thing. We can see its value, but it needs to be in context, and we need to see how it's going to be implemented before we can show support. So at this stage, Mr. Speaker, we have made our position clear, but we are also always looking for ways to constructively improve this legislation. I wish more of this law was actually about education. It doesn't seem to be. Tēnā koe.